The code is really aspirational. It is not law, as Bill has stated. It is an aspirational guide to how to be a good notary. And if you follow these principles, it's very unlikely you'll ever be challenged by the commissioning official for your notarial acts, because this code does set out good practice. It's important to understand, though, the code is not law. It's not an administrative ruling that could have authority, and it's not a judicial opinion which has to be followed in the district in which the appellate court made its ruling. It's just good practice. It's a common sense approach to make sure that you are servicing your clients in the best way possible, looking to make notaries realize they are not the mere perfunctories that some people would like to believe they are. You really have a very significant role in many legal transactions. And if you don't do it right, people get hurt. And that's worse than you being sued, because you could have insurance to cover your lawsuit. But to have somebody's purchase of a home totally come apart because a notary didn't properly notarize a deed, and then the seller backed out and sold it to someone else, and there's this distressed would-be buyer because a notary made a mistake. So even though this is not law, what you do is very important, and don't let anyone else tell you different. Going back to what this code is, I don't think there's any governmental body that would ever turn to this code and say, this is the law. But a court could very well look at this code and say, although it's not the law, it is good practice. And that's not quite as effective as a law, but there's nothing that prevents a judge, when deciding a case which is just based upon facts, a he said, she said, and that judge sees that the notary followed a code of responsibility that has been adopted by a nationally recognized organization, I think the judge is going to say, well, we couldn't ask much more from that notary. That notary did exactly what a well-respected national organization said he or she should do. And that's what this code will do for you. So, although all of the guidelines are important, I'm just going to start with guiding principle 1, refusal without due cause. A notary shall not refuse to perform a lawful and proper notary act without due cause. This is classic lawyer language. It gives you a demand, and then it gives you except. You can't do this, except. And our except, which is very common in the law, is not very concrete. What does it mean without due cause? You've got to explain this to a client, right? A client walks in, wants you to do something, and you say, nope, I have cause not to do this. And the client's going to say, what are you talking about? They just think, well, I'm here, here's my $3 or whatever the fee is, and you have to act. And to explain to them, look, I have certain responsibilities, and this is what I need to do by law, because now we're referring to the statute, what you need in order to execute a notarization. And you can look and tell that prospective client, I'm sorry, I cannot do this notarization because by law, you have not satisfied this requirement. Due cause, I have a good reason not to do this. And I could articulate that reason to you because I don't believe you are who you say to be because I checked your ID or whatever it is. So as a general rule, this says you can't refuse to notarize without proper cause. Flip to standard 1A3. Now, what does this standard tell you? Refusal on reasonable grounds. The notary shall refuse to perform a notarial act if the notary has knowledge or a reasonable belief which can be articulated. In other words, you could defend yourself in court that transaction or document is unlawful or improper. Now, you're not lawyers necessarily, so how do you know it's improper? Well, you could see cross-outs that don't seem to be in the proper place, or they're not properly initialed by the person who apparently made the change. You could see, anytime you see a document with a whiteout, your antenna ought to go up and say, whoa, who did this? So, I mean, there are just some common sense things that come into play that you should be aware of. One thing you should always be careful to do is to scan that document to make sure there aren't things that are insertions that might have not been initialed. You want to make sure that this document has not been tampered with. So here in our illustration, we have a notary who, in looking at the identification documents of the principal, discovers that the driver's license doesn't have the smooth finish that almost all plastic driver's licenses have. It's clear to this notary that this is a bogus license. This is not a legitimate driver's license. That clearly provides reasonable grounds for not notarizing. What is an easy response to that person to complete the notarization? And I know you all know this. Give me something else. That's all. Okay, just give me some other identification. And indeed, if you ever receive a credential that you think is suspect, do not be embarrassed to say, do you have something else as well? Just for my journal. Want to make a journal entry because I never want this notarization questioned. That's an easy way to say, I'm doing this for your benefit, and let the other credential come forward. And if it doesn't, well, then you're going to have to use your good judgment and proceed accordingly. I think my point here is also the interrelation of A1 and A3. You know, A1 saying without due or improper cause, and A3 giving you the reasonable cause you need. This is the standard, the reasonable cause, what will allow you to proceed or to refuse without running into trouble. And you have the authority to determine who you can notarize for, subject to a very important exception. And that's 1A4, discrimination. Well, this standard reiterates what's actually in all of the model notary acts. I'm guessing there are many state statutes that have such provisions that just say, you can't use discriminatory reasons for not notarizing. And the difference between this being in a law and this being in our code is, if you do it in a state where it is the law not to discriminate, and you do, you will be sued. You can't be sued for not following one of these standards merely because it's a standard. You can be sued if what we say in the standard also happens to be a rule of law in your jurisdiction. Think about it. If you were sued for some reason, and that reason was somehow mentioned in a standard, wouldn't you like, as part of your defense, to be able to say, well, I know this transaction went awry, but it's not my fault because I did the notarization and I followed good practice based upon the NNA's standards. The standards are not a rule of law, but the standards certainly do speak to what expected level of competence and diligence is expected in a notarization. We're not saying they're law, but they're good evidence to present to show that you were not negligent in your act. Indeed, in performing your notarization, you took the extra step because you followed a code of conduct that has been promulgated by a very well-recognized national organization on notarizations. That's the beauty or the value of using or following these principles. You're giving yourself another wall of protection. Everything we think is important is in here, and that's why it's aspirational. The person who is the primary beneficiary is you, the notary, and you follow them to a T, and that's the best defense possible.